When the government is either unwilling or unable to defend people, then that right devolves upon either the individual or upon the people as a whole.
Ed, we've been talking about citizenship and civil rights in America. And one of the most important of those civil rights is enshrined in the Second Amendment, the right to bear arms. Why did the founders or the framers of the Constitution, to speak more precisely, put that in the document?
Madison is famous for saying that all just and free government results from social compact. And he was very serious about that. If you think about social compact, people leave the state of nature by consent. They agree with one another to be ruled for the better protection of their rights. So we could say that social compact is the guarantee of equal protection of equal rights. And what it means is that every person pledges to protect the rights of every other person. There's a mutual pledge of each person to protect the rights of other persons. And this is the social compact. So in the first instance, you could say that the social compact is a militia for the protection of the rights of every other person. And no person who is not willing to engage in this mutual protection of rights can be a member of the social compact. So I think that social compact in the beginning is quite literally a militia. Mm-hmm. And so in the first instance, the framers were worried about standing armies. They had this prejudice against standing armies that were a danger to civil society. And so they wanted to have the notion that citizen soldiers, this was an obligation of society to come to the defense of society in times of danger. Well, they were quickly disillusioned of this, because Hamilton in the Federalist Papers notes that we almost lost the Revolutionary War because we relied upon militias.
It was a very close thing.
It was a very close thing, he said, and that standing armies were going to be necessary. One of the complaints in the Declaration of Independence was that King George has kept standing armies amongst us without our consent. The implication was that with the consent of the people, we could in fact have standing armies. And of course, this is what transpired. But
it standing army being an army in being all the time.
Yes, in being.
As opposed to a part-time citizen style militia.
But there was a Militia Act very early, which required everyone over the age of 17 to have weapons and be ready to serve in the militia, the active militia.
Required all men, you mean? As opposed to women.
I'm sorry.
What about these other non-militia serving citizens?
That's true. All men. But in any case, when it came to the Bill of Rights, there was the Second Amendment was added. The debate about the Second Amendment, of course, has always been about whether or not there was an individual right to keep and bear arms, or whether the right to keep and bear arms was conditioned by membership in the militia. And that debate was finally settled not many years ago in the District of Columbia versus Heller case, where the court finally said the right to keep and bear arms was in fact an individual right, and it was not conditioned by membership in the militia. It was a 5-4 decision, and a rather precarious decision. But I did not...
Aren't they all these days?
Well, that's true enough, true enough. You make a good point there. I did not myself think that I would live long enough to see this decision, but I'm very happy that I did. And it was a very important decision because liberal jurisprudence, if that's a word, I think it is, always had a difficult time explaining why the Second Amendment was an exception to all of the rights listed in the Bill of Rights.
Which are all individual rights.
Which are all individual rights. For example, the Fourth Amendment says the people shall be secure in the persons, homes, places, and effects. And we've always understood that to be an individual right. And the people have the right to assemble and to petition the government and so on and so forth. Why is it the people have the right to keep and bear arms in the Second Amendment is a collective right instead of an individual right? And so liberal constitutionalists have always wanted to read the Second Amendment as if it read the militia in the several states being necessary to the freedom of the several states, the militias in the several states shall have the right to keep and bear arms. Mm-hmm. Well, it doesn't say that. It says a militia being necessary to a free state. A well-regulated militia being necessary to a free state, the people shall have the right to keep and bear arms. So I think that on any fair reading, it is an individual right. Now, what the court did say in the D.C. versus Heller case was that the core of the Second Amendment was the individual's right to protect himself in the home. It was a right of self-defense. And that so far the people have chosen the handgun as its weapon of choice. It didn't mean that the right to keep and bear arms was limited to handguns, but so far that was the weapon that was most often chosen by the people. But the court also said that there could be restrictions upon the kinds of weapons used, and it mentioned unusual or dangerous weapons.
And you would agree with
I would agree
those
with
reasonable
that. Yes.
restrictions?
I would agree with that. There are many unusual weapons that I don't think should be widely circulated, and there are many dangerous weapons. I didn't mention that some 50 years ago or more, I was a graduate of the U.S. Army's Advanced Infantry Training School, in which we learned how to use flamethrowers and mortars and machine guns and weapons of that sort. I don't think that they should be widely circulated. Flamethrowers, I don't even know if they're still used in the Army, but they're particularly dangerous weapons, and I think would not be good for home defense, among other things. And so I think that those kinds of restrictions are perfectly reasonable. But the court did mention, Justice Scalia wrote the majority opinion, mentioned that the automatic AR, which is the Army's infantry weapon, could also be restricted. So the extent of the restrictions will have to be worked out by legislation or litigation, so we don't know where that's going to end up.
Assault guns or assault weapons
probably
are
not
ambiguous?
Probably not assault rifles. We'll have a difficult case to show that assault rifles are good for home and personal defense. You notice that Vice President Biden has gone around the country saying that all the people need is a shotgun, and we ought, every one of us, to get a shotgun for home defense. And I think that the purpose behind that is to forestall the idea that we can make a case that assault rifles are good for home defense. And a lot of people are saying that they're not good weapons for home defense, but I think, at least I have defended them as good home defense weapons or personal defense weapons. They're not the best, and they would have to be used by people who have great facility in using them. And if you have an apartment, of course, you wouldn't want to use one because the rounds would go through the walls and perhaps kill your neighbors or wound your neighbors in frightful ways. So you have to think about...
Terribly embarrassing.
Yes, you'd have to think about the use of those kind of weapons. Also, the court said that restrictions could be made on the carrying weapons outside the home in sensitive public places, for example, government buildings and schools. And I take that to mean that there might be a right to carry weapons in public and non-sensitive places as well.
Let me ask you about, so one broad justification of the Second Amendment right is certainly home defense, personal security, the right of self-preservation.
Yes.
The other has to do more with this term of art, as you mentioned, the free state.
Yes.
That is that people who mean to govern themselves have to be able to defend themselves as a people somehow.
Yes.
Against foreigners, but also perhaps against, as in the case of a revolution, domestic revolution, against an oppressive government of some sort. But the paradox which is usually trotted out in this case is that if one needs to conduct a revolution against an oppressive government, you want flamethrowers, or at least you want mortars, and you
Yes.
want heavy-duty guns. You want all the things that the Supreme Court has recently pronounced to be forbidden, or at least highly suspicious.
Yes, that's a difficult question. I think, when Senator Feinstein says nobody needs an assault rifle for hunting, nobody needs an assault rifle just merely for target practice, I don't disagree with that. But that's not the reason that we have the Second Amendment. The Declaration of Independence, of course, talks about the right to alter or abolish government. When governments become destructive of the ends for which they are established, the people have the right to alter or abolish government and to establish new government, which they now believe is better calculated to fulfill the ends of government, which is the safety and happiness of the people. So if the people have the right of revolution, we call it, then of course they also have the right to the means of revolution, and that's the core of the Second Amendment. I disagree with the Supreme Court when it says that the core of the Second Amendment is home defense. Mm-hmm. That is not the core of the Second Amendment, but it is a necessary means to the right of revolution. If we have the right of revolution,
presumably it's an important part in its own, as far as it goes. I mean,
self-defense.
It just doesn't go all the way.
Of course, home defense, self-defense is a necessary part of the right to life. When the government is either unwilling or unable to defend people, then that right devolves upon either the individual or upon the people as a whole, of course. But if you have the right of revolution, then of course you necessarily have the right to the means of revolution. For example, we have some occasions where we can see how this might apply on limited, in limited situations. After the hurricane in Katrina, the police immediately started disarming people in a great outrage. I mean, after the hurricane in Katrina, it was a virtual state of nature. I mean, some policemen were actually engaging in crimes and engaging in all kinds of assaults and mayhem. The people didn't know whom to trust, and the police were ordered to disarm citizens. And of course, the NRA had to file a lawsuit in order to stop this operation. And so there's an occasion where the people, need to have arms, not for the right of revolution, but the right of self-defense when law and order breaks down and there are no regular authorities to defend them, and the right of, virtually the right of self-government devolves upon the people, either acting individually or in concert with one another. Now, we know that the right of revolution, the Declaration tells us this, should not be exercised for light and transient causes. But governments long established should not be changed, carelessly or
right.
For small reasons. But if the evils suffered by the people, if there's any prospect that they can be corrected by the regular processes of government, then we should wait. As long as elections are proceeding, as long as the Supreme Court is still in existence, Congress is meeting. But if elections are canceled, the Supreme Court is arrested, and things of this character happen, then of course the right of revolution begins to devolve upon the people. Now, oftentimes people say, well, how could people oppose the army?
Yeah.
What chance do we have against the army? We don't have tanks, we don't have airplanes, we don't have, munitions of all sorts. Well, I presume that in our government, it is more likely that the army will be on our side, on the side of the people, than they will be on the side of the government. That's the genius of our government, even though we have a professional army these days, instead of virtually a citizen army when we had the draft. By the way, I'm very much in favor of bringing back the draft, but I suppose.
or you could conclude that a successful revolution would be a lot more difficult under 21st century conditions than under 18th century
I think that's probably correct. But if the army is on the side of the people, which I suspect it still will be, then of course the revolution, a right of revolution, and it would be good to have armed citizens for situations that are bound to happen, like Katrina, where citizens could band together and have a modicum of order and so on and so forth. So this is still very, very important today.
Let me ask you a final question about why is it that progressives, broadly speaking, are so hostile to Second Amendment rights?
Well, I think because they're hostile to any a display of independence on the part of citizens. I mean, the idea that people can take charge of their own lives, for example, is anathema to progressivism. And progressives say, why do people need to have guns? We have police, we have the army. They are the experts. Let them take care of security. People don't need to take care of themselves. And to the extent to which people can take care of themselves, assert themselves in their own defense or in their own security, that's the extent to which they don't need government. That's the extent to which government doesn't need to expand and control the lives of people and so on and so forth. That's an affront to the administrative state, to the expansion and to the reach of the administrative state. I think that that's very simple to understand.
Good. That's a good answer. I like that. Thank you, Ed Erler. Thank you, ladies and gentlemen, for joining us on The American Mind.